Judge Rata Mokgwatleng has ruled in favor of the state to lead evidence around automatic vehicle locator. Mokgwatleng says it will be in the best interest of justice for the state to lead the AVL evidence, which the defense was reluctant to be admitted in court. It shows police movements when transporting one of the accused, Bongani Ntanzi. The trial of 5 men accused of murdering former Bafana Bafana goalkeeper For Meyiwa continues in court today. It is, of course, the continuation of the trial within the trial. eNCA reporter Manqoba Mchunu is following those developments, and he joins us now live. Manqoba, just tell us why the defense would not want the state to show this evidence, if it's likely to probably even assist them in terms of where police went when they arrested their clients.
Well, certainly, Masiko, there was a question before court as to why the defense is really objecting to the use of this AVL system, given that it could pinpoint exactly the movement of Sergeant Vusimuzi Mohane on the 18th of June in 2020. And you recall, Masiko, how we got here is through a cross-examination of Mohane, where it emanated last week that accused number 2, Bongani Ntanzi, had been booked out for about 17 hours on the 18th of June in 2020. And of course, there were questions as to why Bongani Ntanzi had been booked out for 17 hours, if at all he had then finished checking out his alibi in a period of about 3 to 4 hours. So the question was, why did it take police so long to return him to his cell? And of course, the defense was contending that this is the period that Bongani Ntanzi had been assaulted and tortured into making that confession, which happened the next day on the 19th of June. So the issue here was exactly where did Mohane take Bongani Ntanzi during those unaccounted hours. And of course, what the state had done is that it wanted to introduce this AVL system, which is a tracking system of the vehicle that Vusimuzi Mohane had been using at the time to pinpoint exactly his movements on that particular day, and perhaps dispel some of those assertions that there was assaulting and torture that had taken place. But of course, we heard the arguments this morning, Masiko, when it comes to that. The state, what he's arguing in court is that it's in the interest of justice for this AVL report to be ventilated in court, because it will provide clarity and it will assist the court in as far as the movements of Vusimuzi Mohane are concerned on that particular day, but also the fact that there is no need for a state witness or an expert, rather, to be called to the stand at this point, because Vusimuzi Mohane is the driver of that vehicle, so he will be able to validate to court the route and the different locations that he had traveled to on that particular day. So their argument was that this should be allowed by the court so that it can assist the court to be then able to reach a conclusion as far as this question is concerned. But perhaps let's take a listen to some of the arguments that were raised by the state advocate just before we get to what the defense had argued.
It was put to Sergeant Mohane that there were pages on which the thumbprint of the accused were not affixed. Hence, they proceeded to Moroka Police Station to complete the process. As already intimated, my lord, we make the submission that these allegations are so serious that they need to be investigated, and if the AVL records can assist in the determination of these issues, it is then in the interest of justice that the evidence on AVL be presented to determine if these serious allegations are true or not. And here, my lord, we're referring to the re-examination. The Sergeant Mohane be re-examined on those AVL records.
So what did the defense have to say in their argument?
Well, the main point for the defense, Masih, was around the timing of the introduction of these documents. Of course, they questioned the timing and even alluding to the fact that the state had dragged its feet when it comes to this particular point, and why really now only is this evidence being introduced to court. But of course, what the state contends is that this is to assist the court to be able to see exactly what had happened on that particular day. So they were arguing on a point of prejudice to the accused, saying that Vusumuzi Mokhane, first of all, is the investigator in this particular case. So his evidence in court will be biased against the accused. They are calling for an expert to be called and to give evidence on this report. So this is someone who will be from the vehicle tracking system, who will be able to testify exactly on what that particular document entails. But one of the issues that they are also raising is the fact that even if that expert is called, they might not be able to give inferences that emanate from this particular report, given that there are no exact places where it's pinpointed that they had gone to. So those are some of the main arguments from the defense, which had argued that this particular document not be admitted as evidence in court. But let's take a listen again, Masiko, to their arguments that they presented in court.
Sergeant Mokhane is not a neutral person in giving assistance on the evidence of these AVL recordings, on the basis that he is a team investigating this matter, and his conclusions will always be biased. May I further make a submission in terms of the above mentioned case? An expert witness should provide independent assistance to the court by way of objective, unbiased opinion in relation to matters with his expertise. An expert witness should never assume the role of an advocate. The time in which this document is intended to be introduced by the state in these proceedings on its own is irregular, and the accused persons will suffer prejudice, because the basis for which this application is made is to reintroduce an evidence to rebut the version of accused number 2. Accused number 2 will still come and testify if a need arises, and the state will have an opportunity to rebut the evidence that is placed under oath by accused number 2.
All right, so Manqoba, when do we expect that this evidence will be laid? Is it immediately after the lunch break?
Well, certainly, Masih, we're expecting the state to continue leading that particular evidence. And this is, of course, after Judge Rata Mokhane had ruled in favor of the state that it is indeed in the interest of justice for this evidence to be led in court. And, of course, his decision was also based on the relevance, given that this is an issue that hinges on the right of the accused. There are serious claims that have been raised as far as accused number 2 being assaulted and tortured, and also hinges on the reputation of those very police officers that had taken down those confessions. The court saying that it has a duty to take this matter further if at all it does show that there was any torture and assaulting that had taken place on accused number 2. So it then reached that particular decision to say it wants to hear this evidence so that it will be able then to make an informed decision when this matter is concerned. Of course, what the trial within a trial is looking at is the admissibility of those 2 confessions and whether or not they were made freely and voluntarily without any pressure or coercion that was involved. So this is quite crucial, Masiho, and we're expecting, of course, that evidence to now be led when this matter resumes after lunch.
All right, Manqoba Mchunu outside the High Court in Pretoria with an update from that trial within a trial in the For Meyiwa murder trial.